just want to welcome everybody. We've got a nice, small, intimate group here, which is great because that way you can have a lot of interactions one-on-one. My name is Scott Welch. I'm the past chairman of the Ohio Independent Auto Dealers Association. I'm sure you guys have all heard the spiel several times by now, so I won't bore you with all of that. Everybody here is a member of the association. I'll save the sales pitch on that. Let's get right down to it. I want to introduce Franco Barile.
Very nice job.
He's from Satilian Barile, LLC. You guys know what you're here for. I'll get out of the way and let you get busy with it.
All right, thank you. Appreciate it.
Thank you.
Thanks, Scott.
Okay, so today we're going to talk about preserving the deficiency balance and knowing your rights as a lender when a vehicle is towed. All right, so we're talking about tows and deficiency balances. So I'm pretty sure you're familiar with deficiency balances. And as far as getting the vehicle towed, it's kind of a how-to, what to do in certain situations. I did teach this class last year, and there's some similarities to it. We did add some documentation as well, so you can kind of see what we're dealing with. All right, so different scenarios we're going to discuss is the replevin process. It's where the borrower defaulted on the payments, refuses to get the car back, and they need to go through a court process to take care of the getting the car back. Vehicles towed by police or government entity, vehicle towed on private property, vehicles at a repair shop, and then finally, if the vehicle has been repossessed, is it worth the deficiency balance, preserving it? So when we talk about preserving the deficiency balance as we go through towards the end of the presentation, yes, you want to preserve the deficiency balance, but you also want to make sure your documents are drafted properly so that there aren't any suits against you, even if you're not preserving the deficiency balance. And we'll go through some of those problems that can occur. So the replevin process, so most courts do still continue to allow a locksmith order, but again, it's through the court system. A bond is required. Typically, a bond is twice the value of the car, so there's a little more cost when it comes to the replevin process. So if you're trying to get the vehicle and you know where it is, and you just can't get access to it, that's when you want to do the replevin process. You don't want to do this if you just can't find the debtor, because you're just spinning your wheels. You're going to use the court system. You're going to add costs just to try to find somebody. When a repo agent is probably as good as the court process of finding. So you really want to use this process if you know where the car is and you just cannot access it. And you can see here, there's a hearing normally set for 3 weeks of a complaint being filed. At times, they will allow emergency order if you know for sure that the debtor is moving away from the state or moving away from the jurisdictional area. That's when emergency order can be done. Very rare instances, though. At the end, the sheriff will assist in recovering the vehicle, and if the sheriff is unsuccessful, you can also proceed with a money judgment. So you can't get the car, and you tried everything you could, you at least can go after that balance that is owed. So not a total loss, but again, if you know where that car is and you can't get access to it, you want to do the replevin process. Okay, vehicles towed by police or governmental entities, typically on the side of the road. I'm sure some of you have seen or had instances where this has happened. Sheriff's required to send notice to the lien holder, which is tough sometimes because if they don't send the proper notice to the lien holder or they don't send a notice at all, really nothing you can do about it. You know, you can't fight against the police or the sheriff or the governmental entity. They have immunity. But what you can do is work with them, because they will then work with the tow company that has the car, and maybe together you can come up with a better way of getting the car, lower the cost of storage. The biggest issue is storage. Impound fees are one thing, but storage fees are the big ticket items. So you want to make sure as soon as you do know, call the sheriff, call the county, whoever's got the car, the tow company, and just start negotiating some sort of price, because while a notice is required by statute, there isn't much you can do if it was supposed to be the sheriff that was supposed to have noticed. And also, if the At times, the court will require a release, and that's a pretty simple process. Our firm does it a lot. You file a motion with the court, and then eventually you get your order for release, and you can get that with the impound lot. So typically, when a sheriff takes a car, they'll send it to sometimes their local impound lot, and they wait for a court order to do that. All right, vehicles towed on private property. The towing facility must search for lien holder name within 3 days of towing and then send notice to the lien holder. Now, this is ever changing. Okay, this statute has been changed a lot. So even when I drafted this, there may have been a change with how many days, when the notice is given. Now there also has to be pictures taken so that the lien holder doesn't have to go to the lot. They can get pictures from the actual tow shop so they can see what condition the car is in.
Got a question.
Yeah.
How good are those photos, I wonder?
They're as good as the person taking them. The statute doesn't say exactly.
I mean, they want to sit there and get some fees. So.
They do, but you know what? Yeah, I know.
I was just wondering.
Now, as soon as you get notice, immediately you ask for the photos, you immediately ask for the fees. It kind of puts you on a clock, because if they didn't send the notice, they can't charge storage fees. And those storage fees are now set in Ohio. It's $17 a day. So you have some wiggle room. Years ago, it used to be, $50, a day, or $70 a day, depending on the tow company.
Mm-hmm.
Not anymore. All right, so that has changed. And like I said, as far as the notice, a lot of I would call it legislature impact has been done to help creditors and lien holders, because they know the losses that you can incur by just a tow shop just not giving you the car and letting those days go by. So again, no notice, no storage, and even when they send that notice, immediately get on the phone, immediately send a letter if need be. We have clients that call us all the time and say, hey, what do we do here? Send a letter. You want to at least stop that clock, or find a point where you can go to a judge and say, we responded. There was a response. We're trying to get this car back. We're trying to get pictures. So a lot of that has to get done still pretty quickly. And at the end of the day, you do want to negotiate with tow shop, because you don't want to go to court for this. All right, so you want to be able to make it very quick, very easy. Then if you have to turn over to an attorney, be able to file a Well, no. There have been times, and our firm has done it too. We've been pretty successful at these things, because they know once we give them the statutes, it's over. Any judge can look at the statute and say, okay, you didn't give them notice, you're not getting the fees. And then there's some things we can do on attorney's fees that can help as well. All right, vehicles held at repair shops. Key point there, lien holder has priority over any shop claim. All right, so don't let them tell you that, hey, we've got artisan lien. Okay, they may have it, but it's behind the lien that's on the certificate of title. All right, so that's always first. I have a practice point in here. While you're protected, again, you still want to negotiate, because then you're going to have an attorney involved and file against the repair shop. So it's always good, and plus you can have a judge that possibly is going to look at it and say, yeah, they put an engine in the car. They made the car better. So if they made the car better, you're going to want to negotiate that. They may have an equitable argument that they enhance the vehicle before they give it back to you. So just a practice point that might be a hairy issue if you go into court, but just know in Ohio, that lien has priority over any repair shop. I think you'll start to see a standard here, a rhythm. You're negotiating. You negotiate with borrowers for cars. You're going to always negotiate with a party that has something that you want back. So just think about that. Obviously, I'm sure you guys thought quite a bit about that issue. All right, pursuing a deficiency balance. All right, so things that we look at, and I know you all look at even when they get into a car, is credit application, income review, social media, maybe that's done or not, and does the borrower own property? So that's what we look at as a firm if we think it's collectible. All right, that credit application is going to be able to verify employment for the last employer. Review social media. Obviously, so many people use social media, but borrowers, debtors at this point, they still use social media. I would call it in an improper way. It's public, and they say a lot where they work. and you can then see, and try to at least pursue them. So on our end, it's good to have those things to look at as you're looking at a deficiency pursuit. But at the end of the day, even if you don't have any of that, a majority of people do work, and that's the key. If they do work, you're able to collect against them. If they have a bank account, if they own property, if they own another car, records can be subpoenaed for assets. So to preserve that balance, obviously the borrower would have to have defaulted on the contract. You've repossessed the vehicle, and then you have to pursue the deficiency. So I'm sure you all know this, but once the car is repossessed, within 5 days you have to send out a notice of default. That notice allows them 20 days to cure the default. So that cure is based on missed payments, a bond. We'll go through some of that in some of the documents I have. But you all know what has to be included in that notice. If you don't, we can go through it. They have 20 days to make good on that cure, or else you can then set it for a public auction. Now, there's a lot of clients that we have, in that notice of cure, they also put in the notice of sale. Okay, so first half of the document is, hey, if you don't cure it for 20 days, second half says, we're going to sell it, here's where we're selling it. You have to give the date, time, and a location, and it has to be at a public auction, and it must be published in a newspaper. And it has to be sent at least 10 days before sale. Okay, so if you've got a 9-day window or a 3-day window, it's not good. It has to be at least 10 days. Once the sale is complete, you then send a notice of deficiency, which details the amount that's owed after taking into account the proceeds from the sale. So these are all of the documents you need to preserve that deficiency. And then we'll go through documents. Yes?
So you're saying there's a newspaper around here that has every repo listed?
Yeah, so what we have is you have a lot of papers, especially on the digital side. We've got a lot of papers where you can show every single car that is being sold on a weekly basis. And every county has a circulation like that.
And Manheim and Columbus Fair still.
Columbus Fair does, yeah. It does. So
There's
there's a lot of
dispatching more these little ones. There could be one little one in a town somewhere.
So it just has to be in a
The law's a
paper.
little dated.
that's right, the paper. That's still being done.
On the site,
And it can be a digital paper.
but
I believe so. The statute just says it has to be run through a general circulation. So, that statute has not been changed in a very long time to account for anything, let
Right.
alone the UCC. The UCC is what every other state, I'm sure some states have their own rules, but a lot of states we're in use the UCC where you can sell a car at a private sale. You can lease it, you can do so many different things and still preserve deficiency. Ohio, you must go through this process. They have UCC plus, that's your plus. Has to be a public auction. Notice of sale has to be sent within 10 days, and it has to be published. And that, I think, is, the publication is really the hard part on that. Okay. So we'll go through this last, and then the recovery options. Okay, so this is what a lot of law firms do. These are all the legal ways of collecting, and this is all post-judgment. So you've now said, all right, I'm done sending to a law firm. You're going to get judgment. Now what do? You can pursue wage garnishment, bank attachment, a sheriff execution. So sheriff execution, maybe they have other assets and a safe deposit box or gun, you name it, something that you can actually mark. You would go, file a press sheriff goes out and they'll do their own sale. That's a longer process to do, and a lot of the subprime that we deal with, we don't do a lot of sheriff executions, not a lot of assets that some of these borrowers have. That is an option. Debtor's examination gets used quite a bit. You send out notice to the debtor. They have to come in person to divulge their assets. And a lot of it is you try to get their wages, where they work, you want to know where they bank, and then a whole slew of other questions of what kind of assets they have. And that's done through court. Charging orders and liens, these are things against companies that you can do, like if they have an LLC, you can put a charging order against the LLC for their LLC interest. But again, those things aren't used as much in this world. Foreclosure, so if you've got a judgment, they own a house, we can do the research and say, hey, they either have a lien on that house or they have no lien at all. let's foreclose on that house. Do you want to do it on a $1,000 judgment? Probably not. But if it's a little higher, we've done a couple of foreclosures, and they usually stop pretty quickly because they want to keep their house, and we, there's settlement involved. But just know that you can't foreclose on the house. And then contempt, which goes along with kind of debtor's examination and wage garnishments, where if the debtor does not show up in court, you can file a contempt, motion for contempt, and do a show cause. And if they don't show up, you can then ask the judge to hold them in contempt. Part of that contempt order is based on county and judge, whether they'll allow for the debtor to be arrested for this specific order. They would have to have been pulled over for something else, and then they would see this on the record. And we've had a couple that have been in jail waiting for our questionnaire. So that still does happen. And same with the garnishee, that would be the employer. If we file the garnishment and the employer doesn't file a response, we can do a motion to show cause, bring them in, and there have been times where we can transfer that judgment over into against that employer. So there's quite a bit that can be done. So don't just think that, well, I'm sure you'll collect or make phone calls. No, there's a lot you can do legally.
It's good for us to know we have employees.
Yes, absolutely. You better respond to wage garnishment orders. Absolutely. Okay.
I'm not gonna do everything.
So
At least once a year.
what we'll do is we're going to go through each of these documents, and this is, again, to preserve that deficiency, but also what we'll go through is what if you don't send those notices. Okay, so this is a model in which I have to end the slide, don't I? Now you can. Okay, so car's been repossessed. Now you have to send a notice of default. Okay, and what this is, it tells the borrower that there's a lot of stuff in here. Contract date, what the year, make, model of the car is, and it tells them that the car's been repossessed. And after repossession, they have 20 days to pay all of this. Okay. As you can see, you've got all installments. That's A, unpaid delinquency or deferred charges. C are going to be your repo charges, but you can only put $25 here based on the statute. If it's more than 25, you can wrap it into the back of the loan. All right, so it's not forever gone, it's still on your pay history. And then a deposit by cash or bond amount of 2 installments to secure timely future payments. So by the time you get to the bottom, it's a pretty hefty amount they have to pay back, especially D. You're looking at 2 payments on top of the installments they missed. So sure, you'll see borrowers come and make that payment and they get the car back. If they get the car back and they default again, no more notice of cure. You only send it once. What you're going to do is go here. So this is a notice of cure and notice of sale combo. And that combo, the bottom tells you, vehicle shall be available for inspection as well. So if you fail to cure the default by 20 days, the vehicle will be sold at public sale. You have to have a minimum sale price. It can be as low as $1, as long as you have some amount that's there. And it may include a lease or license, which is part of the statute. But what's important is the time and place of the public sale as follows: location, name, and address, date and time, and then telling them that they can attend the sale. And if you want more information, you can call us, and this is who we are. These are 2 big important points. The location, name, and address. You better make sure you have the exact name and address of the auction site. Date and time. If you have January 10th, 2024 at 10, and you forgot the AM, you could get sued. Okay, so there have been times where the AM or the PM, let's say it's 1 PM, has been lopped off, and that's enough to get sued. All right, so you got to be really careful. Everything's got to be perfect, because there are consumer attorneys that will still go after that issue, because it is technically a strict liability statute. So this is what the notice and the sale should look like if you are putting them together. All right, you can always send the notice of cure first and just wait. Okay, if you do wait, we have here, it's called a follow-on notice of sale, and you can technically use this as your first notice of sale, but if you go to sale for the first time and the car doesn't sell, you have to reset it for sale. And when you do, all you're doing is setting it for resale. And you can see the language is identical. Okay, but it's got a few extra verbiage in here stating there's another sale. But again, you've got minimum bid, location, date and time, and you can attend the sale. All right, so this is again a follow-on. And whatever, whether it's a first sale or a second or a third or whatever sale, you have to make sure you publish the sale. And that a lot of that gets done through your auction company. We have a lot of clients that use an auction company that would then do this for them. However, we've also seen at times where auction companies don't do it timely, or maybe the paper didn't publish it correctly. Okay, so that 10-day mark is very important if you're preserving that balance, because if you have 5-6 sales a month that go through the same auction company, same sale, and something's wrong, every single car, every single week, you cannot collect that deficiency. You can't preserve that deficiency. So everything has to be kind of tightened up. All right, so that's the notice of sale. And then when all is said and done, and you have now done the proper procedure, you then have to give them a notice of deficiency. Now, sure, it's a notice of deficiency or surplus. If you've got a surplus, great. Guess what? You still have to send this notice. And it goes through all of the points in order to collect on the deficiency. So it gives you at the very top, what's that aggregate amount before the sale, how much was the sale, and it's just a math procedure at that point. And as you get to the bottom, were there other expenses, preparing for disposition, processing, disposing of the vehicle? Okay, yeah, you have to use a repossession company. You have to do so many things to try to get the car. You start adding these things back into the deficiency balance. And if you had any rebates or any credit service charges, that's where you put this line. And then the amount of deficiency, that's the bottom line. That is the total balance that's owed after sale. This must be sent after sale. There is no time period of when to send it, but before you sue, this must be sent. And it can be sent by first-class mail. So one thing I did fail to say, which is the final point of making this very strict, is that if you're going to do a notice of cure with a notice of sale, or if you're just going to do a standalone notice of sale, the notice of sale has to be sent out by certified mail. All right, so that's another key point. Certified mail, so that the statute says certified mail, so you have to send it out by certified mail. The notice of deficiency has to be sent, you can send it by first-class mail. So just know there are different ways of sending these things. If you just did a notice of cure, that does not need to be sent by certified mail. It's just the notice of sale. All right, notice of sale, certified mail, published in newspaper, at least 10 days before sale.
Pardon my ignorance. If you send something out certified mail and they don't sign for it,
They don't have to sign for it. It's the last known address.
as long as it went certified mail, the last name address, and hits their box, you're done.
You're done.
But it just has to be shown that it was sent. You have to prove that they got it.
Yeah. So yeah, all you gotta do is make sure the certified mail's out. You keep the green card. A lot of it's electronic now. Whatever
Right.
proof you have of being sent. Stick
So
it
they
in the
can't
folder.
dodge it on that.
Yeah. So yeah, so this is everything. Yeah, if anybody has any questions, obviously went through quite a bit of information in a very quick period of time. But again, if this is not just preserving that deficiency balance, even if you don't want the deficiency balance, even if you don't want to pursue it, that notice of cure, that right to reinstate by statute must be sent. So if you say to yourself, I don't care for the balance, make sure you send that notice of cure. You've got to give them that opportunity. If you don't do the notice of sale properly, if you don't do the deficiency letter properly, if you don't sell it properly, whether that's okay or not is debatable, but it's not the end all. If you don't send that notice of cure, you could get sued yourself. A lot of dealers are worried, a lot of independent dealers are worried when they file suit that they'll get the countersuit. right? They don't want to poke the bear. But don't forget, you don't even have to poke the bear. As soon as you repo the car and you don't send that notice, or it's not properly put together or sent properly, they can sue you. And if these documents that you have are improper and you've done it in a long period of time, there's a potential that if you do get sued, it's also a class action lawsuit. All you need in Ohio is, I think it's federal, within 25 and 40 cases, you're in class action land. So that's why it's very important to have these documents buttoned up. So hopefully I've pressed it enough to let you know. I'm sure you have your own default notices, and I'm sure they comply. But if they don't, the statute's there, and we also provide that as well for our clients. So, well, that is the preserving the deficiency balance and knowing your rights as a lender when a vehicle is towed. Any questions? Yeah.
So the impound fees is only from the time they sent you the notice?
Yeah, but as long as it's not that a public tow from a governmental entity, if it's a private tow,
So they get
it's
pulled
from the
over,
notice.
they get pulled over driving without a license. Like usually in our area, they'll send it like 6 to a year after.
So that would be considered a governmental tow. That the sheriff, I was assuming it was up
Yeah.
taking the car. They're supposed to send notice. That's why as soon as you find out, you have to get on the phone and try to work with both sheriff and tow company. Because the tow company's gonna say, well, the sheriff's supposed to send that notice. Now, I do believe that statute is getting some traction and getting changed to where the tow company, as soon as they have it, they have to send notice. But I don't believe that statute's been changed yet. So if it's a public tow like that, it's more conversation.
And I got a couple, but go ahead.
I think you're it.
Okay, what if like we take the car to the auction, it brings like low money, and we don't want to sell it, we keep it.
Well, what do you mean it's low? So I see, so you're watching it, and you notice that there's
So
not a lot of
like,
bidders.
it's a $2,000 car, let's say. and
Somebody
only
has to
brings
buy
like
it.
five. Can we buy
You
it?
can rebuy it, yes. If it's done properly, public auction, published, at least 10 days before sale, you can buy it.
What's the minimum dollar amount to repo a car?
Doesn't be higher.
Yeah, that's more agent, I would say.
So like, let's say somebody only owes 500, can I go grab the car still?
Yeah.
Repo it?
Yeah, if you have a balance, absolutely.
So there's no minimum amount of balance, like some people be like, oh, it's only like certain amount, you can't
Well,
repo.
tell them to pay it off.
Okay.
If there's a certain balance, you can pay it off, but I mean, at the end of the day,
That's a business decision.
yeah, you're looking at whether you wanna go after it or not. If it's a default, it's a default. Yes?
Is there a good place to find these forms that?
These we call them proprietary, so this is from my firm. But if you've got my business card, just give me a call and, we can discuss on getting those together. This is based off the statute, compiled together. So yeah, it's not something that's out there that's formed, because somebody else's documents could be good enough that don't look like this. So nothing quite canned yet.
For example, now I took a small video. So can I copy the same?
But
But no, it is a lot, no, I'm serious, like, it is something legal to do, or?
Yeah, you're free to, if you saw it, that's fine. And that's,
Okay.
also, if you call my office, we can
Okay.
help provide that as well.
Okay,
But just know that sometimes the statute changes,
yeah.
and don't take this like this is what it is for all time. Things can change. So this disclaimer, we can just tell you that, hey, while this is good, it may not be good tomorrow. So whenever you call our office, we do the same. We have it on our forms at the bottom that things can change. Has it changed in a while? No, but it could. It could. Just a little disclaimer there.
So if I have, let's say tomorrow I have a repo, let's hope not, but let's say I go Monday and I have a repo. So what should I do? Like, I'm sorry, I'm very new to that.
Okay.
So it might sound stupid. So what exactly I should do now?
Well,
Give me
once
like-
you've repoed it,
Yeah, let's say I found a car, I find where the car is. So tell me step by step. Like literally.
number one big step, you send out that notice of cure
So that's the first thing ever I have to do before I call my towing company and tell him, go ahead.
Oh, you mean you're waiting to get the car?
Yeah.
Okay.
I know, I found out, like, let's say Monday, I've been looking for a car, and now finally I know where the car is. So.
Call the repo agent.
Yes.
Go get the car.
And then.
Once you have possession, send out that notice. Within 5 days of repossession, the notice must go out.
I always thought you had to tell them before you sent the repo agent that, hey, you're in default. We're gonna come get it if you don't. Then a certified letter.
That helps. Any of your notices, any of your letters help. This is pure default. Okay, so whatever your contract says on default, you can go repo the car.
No, but it's like I have to tell the customer that I'm gonna repo your car, or I just repo the car?
You have a right to repo the car based on your contract. Okay, so if they missed a payment, when they come into the dealership and they sign that paperwork that says, I'm getting this car, it also has all those other provisions that says if I default, what can happen. And the what can happen is repossession. So whether they know it's coming or not, it's
They
really
say
up to
it
you.
verbally, because some customers, they signed, and most of them, they don't know what they're signing for.
You know, we can't get into the mind of the borrower. You take them as they are. So they come in, you give them the documents, you tell them what's in the documents, they go. They know where to make the payment, how much the payment is. You know, there's a certain TILA box. You have to explain to them what's going on in that box. You know, tells them what the payments are and all that. After that, they are supposed to be able to read that contract. They can sit at your lot for as long as possible to read that contract.
Okay.
And
So
then
they
sign.
cannot say, oh, I didn't know about it, oh, I didn't see it,
No,
or they didn't
of course they
explain
can
it.
say that.
They
Of
get a
course
copy
they
of
say
that too.
They will say that.
But to
Yeah.
say myself, isn't it better to put like the initial of their, like I would make sure where, if there's a spot, I want the customer, I wanna make sure that he understood me.
So your contract, I don't know what you use, but
Yeah.
your contract should have a signature on one of the pages that executes it, but every page must be initialed. So that's, yes,
Yeah.
you do want to do that. And the Ohio, I think it's called Ohio law forms or are, whatever they are, they're pretty good. So the standard forms are still pretty good. Maybe they're missing some charges that should be included, but the standard forms are still pretty good, and a lot of them have all this language in there.
Okay, perfect.
So how,
Yeah, there you go.
yeah. Reynolds and Reynolds, so,
Yep.
they're the only ones to sell.
Any other questions?
Hey, what about like some, like repo companies, they charge the customer to regain his belongings out of the car, and
Charge?
yeah, and one time, yeah, even the auction, like Akron Auto Auction would charge them like $75 to
You know, you gotta talk to them. I mean,
They
you're
say-
supposed to have the car open for them to take their
to
personal
take
property.
that, yeah.
I wouldn't charge. And if the company's doing it, maybe tell them, don't do it, I don't know. Yeah, I wouldn't.
Like we had to pay it before.
You paid the auction company?
Yeah, so then just go get it.
I don't know, I would think it's more rare that that's happening. Would hope. Yeah,
Personal belongings.
Yep.
They put it in this stereo and they have subs in the trunk, speakers in the doors. Are they allowed to remove this? Considered personal belonging? Or is that part of the legal?
I'm glad I brought the partner of the firm here, if he has any insight.
Yeah, so, just a couple things.
No, just on the speaker. The speaker.
In the contract, and that's where like, if whatever form you have is important, it'll say like, there are actual terms in there. Like, there are non-payment defaults that constitute a default. That means you can repo the car. Not all defaults are failure of payment. One of the other things in there is, you know, you agree not to do X, Y, and Z, like put things on there or whatever, or remove those, you know, upon turning on the vehicle, that kind of thing. So that is more contract driven. It's not legal driven. Look at the, if you're buy here, pay here, and you control your own contract, basically, that's a provision you can look to put in there. Maybe Allison can help you with that. If you're doing a Reynolds and Reynolds or something like that, they're very specific, but look at like, you know, either the back of the long form or page 2 through 6, you know, and they have all those things, just like there's different forms for collateral place insurance and things like that. it'll tell you about adding things to the vehicle beyond that were there when
We
you
need
bought
a
the car.
separate form since we're using bankers.
Now, I'll tell you what, we're always learning something new. Let me do some research on that. That's an interesting topic. No one's ever brought that up. It almost sounds like an asset of the car
Right.
instead of their personal
We've
property.
always considered if it's bolted down or why.
Yeah.
Rims and tires.
Why exactly? Why don't you pay $2,000 for the rim?
Yeah.
Make your payment, but you
I'm,
stay on
I'm
the car.
sure there's cases on that issue, so let me do some research on that and get back to you. I do have your contact information, so I will send it to you.
Excellent.
Or,
Appreciate the question.
send us your contract,
Yeah.
and I'll find it for you.
I'm sure you already got some of them.
Yeah.
Oh, really? Really good one. Yeah, thank you.
Guys, this has all been recorded. You can go to our YouTube channel on the OIADA website, on OIADA's YouTube channel, and rewatch these. They'll be available in about 2 weeks. Does anybody have any more questions?
And if not, I'm around. I can always walk around and ask you
I'll
questions.
throw one more up, if that's okay.
Yes.
If one of these guys repossessed a car, the guy paid it down from 10 grand to 3 grand, he just turns it in, but it's worth 5 grand. But they don't send it out for deficiency. So there's not gonna be a deficiency. Can they
Oh, I see.
resell this vehicle under law?
So what you're required to do is send out that notice of cure, all right, they can pay that. After that, now you're really just preserving whatever that balance is. So if you're looking at, I would say take it back. Part of the cure, I'm not sure. I think it's a great question.
Because so it brings more at the auction, then
Yeah.
then you have to.
Then
pay
you end up
them.
having a surplus.
Yeah, then you have to pay them, but if we just don't charge them over, if we just charge it off, write it off, and we don't go after any type of.
You're 2 for 2 today.
And that's awesome.
Yeah, I'll send you an email and I'll send the group an email as well. That's a very interesting question if you're gonna end up with a surplus.
These are all
we're
things
using
that happened in
deficiency
the last
rule.
10 days.
Oh my goodness.
So stay
We're in
tuned for
deficiency
more
rule
info.
usually. We're rarely in surplus. Yeah, I appreciate it. Yeah.
If I had a repo situation, I haven't had one in years, but if I did, and I'm like, I don't mess with all this. Should we just call a firm like yours and say, hey, would you guys take care of sending this customer bill?
Yeah, what we can do is help you prepare that form. We can't draft it, but we can help you prepare the form and then help you get it out and make sure it's done properly.
My other thought was if they see it coming from the law firm.
Yeah. True, but no, we can't run our letterhead. What we can do is we can help get you that document that was statutorily prescribed.
Okay, thanks.
Thank